University of Arizona Online brings a top-ranked education to you. Choose from 150-plus programs, learn from the same faculty, and earn the same degree as on-campus students. Apply today and make your tomorrow amazing.
Good afternoon again. This is Dr. Olu Asekun here. Welcome to my podcast. Today is another Wednesday, the 5th of April 2023. You are welcome. Our plan is to continue doing this every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. You are welcome. Please subscribe to our channel so that when we go live, you can get notification. Also, invite your friends, family, so that you are not selfish. The purpose of this is to continue to provide education, free information to people so as to avoid mistakes or errors. So it would be unfair for you to have access to this information and prevent other people or not encourage other people to have similar access to this information. You may believe that you don't need this information today, but you never know where it may be handy. You never know where it may be useful. Even if you are a U.S. citizen, you may need the information in the future. You may have family members or friends that you can prevent from making avoidable mistakes or avoidable errors. So it is very important that you not only join us, but you also tell people so that they take advantage of this free information. This is free of charge. We are not charging anything, and we don't have any hidden agenda. It's a free program. So join us every Wednesday, 12 p.m. Central Standard Time. That is Dallas time, about this time, every Wednesday by God's grace. So, welcome to this podcast. Today we are discussing VAWA. VAWA means Violent Against Women's Act. So, some categories of people are eligible to file a petition as a self-petitioner, someone who is a victim of abuse from a United States citizen, spouse, that is husband and or wife, or even a permanent resident spouse, husband or wife, or even from a fiancé. So, a victim of abuse could be, like I said, a spouse, that is husband and wife. It could also be a child, and in some rare cases, the victim of abuse could also be parents of a U.S. citizen. We have seen all these situations, so it's not a guesswork. We are not doing guesswork here. We are talking authoritatively, things we have done and get approved. We have represented a parent, a mother of a U.S. citizen who herself was a victim of abuse, and we were able to get her legal permanent resident status. So it is not, VAWA is not limited to spouses alone. It is not limited to husband or wives alone. Children, parents, all of them could also be victims of abuse, in which case they may be eligible for VAWA. So it is very important to clarify that. Now, I want to sound this note. As I said, today we are discussing VAWA. So keep the questions coming so that by the time I finish the little introduction, we could go into questions and be able to answer our questions. So keep the questions coming. But in the meantime, I want to say this again from experience. I've seen people who are not eligible for VAWA and they apply for VAWA. In fact, I see this a lot. There have been situations where people will consult with us and we will evaluate the case and make a determination that the person is not eligible for VAWA. Then, a few months later, you find out that another lawyer has actually filed VAWA application or VAWA petition for this particular person. Well, I cannot speak for what other lawyers do, but I do know that some people do this thing for money. But it is always good to be mindful of the consequence. Sometimes the client is the one that will be at the receiving end, and a frivolous VAWA application could actually lead to a permanent bar. And I will need to explain all that today by God's grace. So in the meantime, keep the questions coming. Keep the questions coming so that as we proceed, I will see the questions and be able to answer them. So just a minute, let me just check and be sure that I have access to the questions when they start coming in. I think I'm frozen here. I don't know. Okay, yeah, I think somebody said we should increase the volume. Can you please? Okay. Okay. Yeah, we got the message. I believe the volume has been increased. So as I said, today we are talking about VAWA, that is violence against women. And this is one of the most abused area of immigration law, to my knowledge. As I said, we have seen people who are not eligible for VAWA, and when they come here, we evaluate their case and make a determination that they are not eligible, only to find out that some other lawyers will file VAWA petition on behalf of these same people that we believe are not eligible. So the point I'm making is, in as much as I don't want to talk about how other lawyers do their practice, but I do want to point out that some people do these things for money. Some people just file petition whether the applicant is eligible or not. They just want to make money. So whether the end result is okay or not, they don't care. They just file the VAWA as long as you pay. But I'm saying today that you have to be careful, because a frivolous VAWA application or a frivolous VAWA petition may actually have a permanent bar consequence. So at the end of the day, the lawyer is not going to be affected. It is the client that will be the victim, and he or she is the one that will suffer the consequence of the frivolity. So that is why I want to advise you to be extremely careful before you submit a frivolous VAWA application. Having said that, let's go into VAWA. What is VAWA? It is a provision of the immigration law that allow a victim of abuse to be able to self-petition for as long as 3 conditions are met. What are those 3 conditions? 1, the petitioner or the victim of abuse must show evidence that he or she actually live together with the U.S. citizen, spouse, parent, or even fiancé of a U.S. citizen or a legal permanent resident. You have to show evidence that you live together as husband and wife. Now, this is where it gets tricky. Showing evidence that you live together as husband and wife, evidence could be in many forms. It could be, you may have to show joint lease agreement. You may have to show either joint mortgage. You may show joint maybe renters insurance. You may show evidence of commingling of assets, utility bills, joint bank statements, and other things that a normal husband and wife will do together. But like I said, the danger with filing a frivolous VAWA application is this. 1, the VAWA office is going to rely on 3 things to conclude or to evaluate or to make a determination whether the applicant and the abuser, the U.S. citizen or permanent resident spouse, actually abuse this person. 1, they are going to rely on the story that you present, because when you apply for VAWA, you have to write your story. You have to write the story of what happened to you. How did you meet this person? How long did you date? When did you get married? What was the situation of your marriage? What was the situation of your life after marriage? So at what point did your relationship become abusive? You have to write all these stories. What specific incident of abuse occurred during the marriage or during the relationship? So you have to state all these things in writing. So that is your story. So the VAWA office is going to consider your story. The next thing the VAWA office is going to consider is the supporting documents. What supporting documents do you have to back up your story? So they are going, that is where all the documentary evidence of commingling of assets comes to play. So the VAWA office will consider that as well. Now, this is where it gets tricky. The VAWA office will also now use public record to verify those stories that you wrote and the documentary evidence that you submitted. So in other words, it is not enough to just submit a joint lease agreement, to just submit joint bank statement and submit all these things. If indeed you actually did not live together with this purported abuser, it becomes problematic when public record shows otherwise. Then at that stage, the applicant becomes, the immigration will conclude that the applicant lacks credibility Now, when an applicant is determined to lack credibility, a lot of other bad things follow. I will get to that later. I'm still discussing the requirement at this stage. So the first requirement of VAWA is to show that you as the victim and the abuser, you actually live together. And like I said, they will consider your story. They will consider the documentary evidence you submitted in support, and they will now use public record to verify these stories. Now, before I go further, to tell you how VAWA office is detailed when using public record to verify these stories, I'm going to give you an example. Some years back, I represented a client who was a victim of abuse, and we filed VAWA. The client wrote her story, and we backed it up with documentary evidence of abuse and all of that, and we submitted it. Now, when immigration was reviewing it, they issued a request for evidence. In my years of experience, and I believe that I have quite some years of experience in doing this, I usually, when I review a VAWA story, if I give it a pass mark, I don't think I've ever seen anyone that I give a pass mark that was denied. I can tell you that I have 100% approval rating if I file it. Now, in this particular case, immigration issued a request for evidence. And that request for evidence, they stated that, okay, you claim that you and this person lived at XYZ address. You stated that XYZ address was on Collins Street. But we want to tell you that XYZ address was actually not on Collins, but was on a different street. They mentioned the street. And I was, really? So these people go as far as checking the exact street to actually confirm that the street you are mentioning, those streets exist, and it was in the same exact proximity that you listed in your story. At that stage, that was a new thing for me. But again, that is part of where experience comes to play. Long story short, that particular case, to God's glory, was approved. But I'm just telling you how deep or how detailed immigration is when they are using public record to corroborate your story and the documentary evidence. So, going back to the requirement, the first requirement of VAWA is to show that the victim and the abuser actually live together as claimed. So, my advice to you, if you know that you didn't live together with this person, I will advise you to think twice before you file your VAWA, because they are going to check it out using public record. And of course, we know the implication of a determination of application filed for the purpose of evading immigration law, Section 204C of the immigration law. That makes a future petition, the approval of a future petition, impossible. So that is one. Now, the second requirement of VAWA is to show that the victim was actually abused. Again, this is very tricky. When we are talking about abuse, we are not talking, well, there's a cultural problem here. Based on experience, we have seen different cultures with different determination of what constitutes abuse and what does not. But what I want to tell you today, as an expert in this area of law, is that in writing your story, you have to defer to American culture. You cannot use your culture to determine what constitutes abuse and what does not. We see all kinds of stories. I mean, sometimes I will read VAWA stories and I will just keep laughing to myself because of the nature of what the applicant or the victim will state as what constitutes abuse. Let me give you a couple of examples. If your spouse drinks alcohol, or your spouse maybe is cheating on you, he goes out late night, comes back very late, drunk, cheats on you and all that, let me tell you, listeners, those are not abusive actions. Those actions does not constitute abuse. If your spouse is cheating on you, if you don't like it, you go and divorce. That's why there is a family court. That's not an abuse. It is an action that you don't like, but there are remedies. That does not constitute abuse. The way you have the right to do whatever you like with your life, your spouse also have the right. So if your spouse decides to go and drink, go to club, come back at 2 a.m., that's not abuse. If your spouse decides to smoke marijuana or some other drugs, he is taking it into his own mouth. It is affecting his own health. It has nothing to do with you. That's not an abuse. So if you are putting stories like that together to say that you are being abused, you are not, my brother or my sister. You are not being abused. That's not abuse. That does not constitute abuse. That's not abuse. The only time it becomes an abuse is if, as a result of the drunkenness, if he went further to now start striking you, hitting you, then it becomes abuse. But if all he does is to smoke or to drink, come back late, womanize, cheat on you, that's not abuse. So these are some of the very, very technical areas of this immigration law. So when you put up all these stories, if your story does not constitute abuse, it's not going to be approved. Okay, I know that somebody is thinking, okay, you are saying all these things does not constitute abuse. Now what constitutes abuse? One, what constitutes abuse is manipulation. When the U.S. citizen's spouse is manipulating you, doing something to make you obey his or her bidding, forcing you against your will to do things that you ordinarily will not do because you don't have a choice, using his or her influence to kind of manipulate you, using his or her influence to kind of subdue you, to threaten you, to make it look at, if you don't do this, you are going to be in trouble. If you don't do this, this is what is going to happen. Let me go further. Maybe as a woman, you dress up, you want to go to a party, and your husband says, you know what? That cloth, no, I'm not going to allow that in my house. You can't wear that. You have to go and change. Oh, you are too exposed. No. You have to go back and cover up. Go and wear something that covers your body. You can't wear this. That is abuse. So it is very important to understand all these things. Again, there are cultures. There are cultural implications of these things. So we are not using foreign culture. We are talking about American culture here because we are discussing American immigration law here. So all these things, it is important that we have a clear understanding of what constitutes abuse and what does not. Now, that is the second requirement. The third requirement of VAWA is to show that even the victim or the applicant, you yourself, you do not have criminal record, or you are a person of good moral character. So in other words, if you are not a person of good moral character, or if you have not been determined to not have a major criminal record, then that is when you are eligible for VAWA. But if you have criminal conviction, or if you yourself have done something that shows that you lack good moral character, it doesn't matter whether the criminal offense was here in America or outside the US. It does not really matter. So what is important is that you do not have criminal record and you are a person of good moral character. Those are the three basic elementary requirements. There are other things, but again, those are the basic ones that if you are able to show all these three, then you will be able to get you may be able to qualify as a self-petitioner. Now, I'm going to explain something. Let me see if questions are coming in, but I'm going to raise some. Okay, I think we have questions, but I'm coming back to, before I start answering the question, I want to explain something, because this is one of the things I see all the time, regularly. And that thing is, you see, people don't understand. Again, this is a cultural problem, especially for my fellow Africans. This is a cultural problem that we need to understand. I've seen this over and over and over and over again, especially when it comes to asylum, VAWA, and some other form of petitions. Whenever people get work authorization, they conclude that their case has been approved. I have said this over and over and over again. No, your case has not even been looked into. Now, because we are discussing VAWA, I want to discuss what we call prima facie evidence, the prima facie letter. I have seen people who received the prima facie letter and concluded that that means they believe their story. My brother, my sister, my listeners, no, they have not reviewed your story. Let me tell you the way this thing works. Anyway, prima facie simply means preliminary. Am I frozen? Prima facie, I see that I just making sure people can hear me. Okay. Prima facie, from the name, it simply means preliminary. Preliminary. So the way this thing works is that whenever you send something to USCIS, it does not go to the office where they are going to process it directly. Maybe for those of us who have been in this country for a long time, you remember the days of anthrax attack, when people will open mails and they will be exposed to some chemicals which were harmful. So the days of anthrax attack. So since then, whenever you file something with immigration, it does not go to the office where the application or petition is going to be treated. The applications or petitions goes to a place called mail room. Now, when it gets to those mail rooms, of course, people who are in gas mask and all of that, so that even if they open the envelope or anything, if they open anything, they see that they are safe. So this thing goes to the mail room. So those people at the mail room, they are the one that will open the mail. Now, these people has been given what we call checklist. So when they open your mail, they look at the type of application, they look at the checklist. Now, the checklist says 3 things must be attached to this application. You must see evidence that they live together in this application. You must see evidence of abuse in this application. You must see evidence that this person is a person of good moral character in this application. Now, they look at the checklist and they mark it one by one as they see those three things. So if any of those three things are missing, they reject it. They send the application back to the petitioner or to the applicant. They reject the application. Now, if those three things are there, then they check it, those three things are there, they accept it, they issue receipt notice, and then they issue prima facie notice. Now, like I said, this is not the officer or the office that is going to look at it. This is not the office or the officer that is going to process the application. So the mere fact that you have received prima facie letter does not in any way tells you that your application has even been looked into by the office or the officer who is going to be working on it. So it is very, very important, very, very important that we understand these things. Now, let me go into the questions. Maybe I will have opportunity to explain further, but let me just keep going to the question. We still have 2 hours, so we have time. We will discuss a lot of these things. Question. Okay, this one question came in yesterday. Is it better to stay married to the abusive USC spouse? Is it compulsory to get divorced before filing? No. The answer to both questions is no. One, you don't have to stay married to this person. In fact, the government does not expect you to stay in an abusive relationship. That is why whenever you file a petition for VAWA, they will provide you information about different areas where you can get help. They send you phone numbers of national hotline where victims of abuse could get help. So they don't expect you to stay with the abusive spouse. So as soon as you make a determination that you are being abused, you should stay away from that abuser. So you can move out of that property, you can move away from the abuser. And secondly, you don't necessarily have to be divorced. You can move out and file your petition, but you may also decide to submit your petition. But either way, it does not affect the petition. Whether you go straight ahead to file for divorce or you wait and take your time, either way, it does not affect your petition. The only benefit is if you file for divorce before you file your petition, you may have additional evidence, because in your divorce, you may not make this allegation of divorce of abuse, and if after trial in your divorce case, if the court finds out or make a determination in their ruling that you are actually abused, that will be additional evidence that you are going to present to immigration so that immigration will believe you. So that is sometimes why it is advantageous if you divorce. But again, it's not compulsory. So you can still do it without divorcing. The next question. My VAWA has been approved and my green card application is pending. Will I need to attend an interview with immigration? Yes, because VAWA petition is different from green card application. They are not the same thing. For VAWA petition, you don't need an interview because they don't interview people for VAWA. That is why I explained at the beginning. They look at the story that you wrote, they look at the documentary evidence that you attach, and they use public record to verify those things. So you are not interviewed. But for the green card itself, that is an application for permanent residence. Yes, majority, not all, majority of applicants for permanent residence are interviewed, because if you look at the application itself, the I-485, there are a lot of security questions in that application. Have you ever been arrested? Have you ever committed a crime? Are you here to practice polygamy? Are you a terrorist, or are you related to terrorist organization? All those security questions, those are things that they want you to answer under oath. Because when you answer in your application, that may not be under oath, but when you appear for an interview, you are asked to raise your right hand or left hand, as the case may be. You will be asked to raise your hand and swear that everything you will say will be the truth, the whole truth, and nothing but the truth. So you are now being interviewed under penalty of perjury. So that's a requirement even for VAWA applicants. But again, in some limited situations, the green card could be approved without an interview, but it is not common. The next question. Do I need a sponsor to sign for I-864 when filing for adjustment of status based on VAWA? No, you do not. You do not. The next question. In order to file VAWA, does the abuse have to be physical? My husband is emotionally abused, yells at me, is financially abused, control my money. Does this count for VAWA? Yes, maybe this person is just joining us. I already explained all these things at the beginning. Yes, if you are being financially controlled, physically controlled, emotionally controlled, yes, those things constitute abuse. Yes, it does not necessarily have to be physical. Even though when it is physical, it is also an abuse, but it does not necessarily have to be physical at all times. Next question. I'm already out of status and I'm currently married to a permanent resident. We were previously told that we could not file I-130. It's really abusive to me. Can I file I-360 VAWA? Well, to whoever sent this question, whether your husband is a permanent resident or not, he can actually file I-130 on your behalf, whether you are in status or not, and whether he is a permanent resident or not. So whoever told you this is not accurate, is not correct, or maybe you didn't understand whatever the person said. But to go back and explain it, a permanent resident can petition for someone, either the person is out of status or in status. Either the person is in the U.S. or outside the U.S. Either the person entered the U.S. legally or entered the U.S. IWI, entry without inspection. A permanent resident can file I-130 petition on behalf of a spouse, that is, husband, wife, or even on behalf of children under 21 and unmarried children over 21. So for all of these things, a permanent resident can file I-130 petition. It does not matter the status. Now, I'm assuming that this person probably didn't understand the difference between I-130 petition and I-485 adjustment application. A permanent resident can file I-130 petition for anyone irrespective of the status. Spouse, children under 21, unmarried children over 21, a permanent resident can petition for them. Now, if you are out of status, what you cannot do is to have adjustment application filed. Adjustment application is a self-application. The applicant is the one filing that, but you cannot file that if you are out of status. When the petitioner, when your spouse is a permanent resident, you will have to wait until your petitioner becomes a U.S. citizen if you are in the United States and you entered legally. Now, if you did not enter legally, let's say you enter without inspection, even as a permanent resident, you don't need to wait for your spouse to become a U.S. citizen before you file I-601A waiver. You can still file I-601A waiver using your husband as a qualifying relative. So all these things, you don't need to delay. You don't need to waste time. You don't need to keep waiting for your husband to become a permanent resident before you can do all of these things. So it is very, very important that we understand the difference between somebody filing I-130 on your behalf and someone applying for adjustment of status. Now, the second question is really abusive and all of that. Yes, if you can prove abuse and you file your I-360, what you cannot do is to file the I-360 and adjustment concurrently. You will have to file the I-360 first, standalone I-360. If it was approved, then you can now apply for adjustment of status. So I believe I've answered that question extensively. But if you still need any clarification, you can send additional clarification request. Next question. I have a pending VAWA petition and I'm in removal proceedings. Is it possible to get my case dismissed based on the petition to USCIS can process my I-485 instead of the court? Well, you didn't indicate that your VAWA has been approved. So if your VAWA has not been approved, your case may not be dismissed, because a pending application is different from an approved application. So if you have a pending VAWA petition, that is not a ground to have your case dismissed. But if you have an approved VAWA, yes, the court may dismiss your case, or the government may also request that the case be dismissed to allow USCIS to process the adjustment of status. So, but if you are talking about dismissal based on a pending VAWA, no, that's not the way it works. Even though, I need to also add, even though the government may file, they may use their discretionary authority to request that the case be terminated while your VAWA is pending. But that is something that only ICE can do, not the court. The court cannot do that, but the government can do that. ICE, those are the lawyers that represent immigration in court. They can do that. They can use their prosecutorial discretion to have the case dismissed, but the court cannot do that. But if the VAWA is approved, either the court or ICE lawyers either of them can have the case dismissed to allow USCIS to adjudicate the adjustment application. Next question. Can I remarry while my VAWA is pending? It has been pending since 2021, but I have now met a good man that I want to marry, but I'm concerned it may affect my petition. Yes, it will affect your petition, because once a VAWA petitioner remarries, that VAWA will be denied by operation of law. So yes, if you remarry, it will affect your petition. You have to wait. Either you have to make up your mind either to wait for the VAWA to be approved, or you go ahead and remarry, withdraw your VAWA, and let your new spouse petition for you. So you have a choice to make. The next question. I'm not currently eligible to apply for green card. Will I get employment authorization while my I-360 is pending? No. Employment authorization based on VAWA is only issued after VAWA has been approved. We need to understand that this is one of those confusing areas that people have issues with. When your VAWA is pending, VAWA, the I-360 petition, is not associated with employment authorization. But whenever a VAWA petition is approved, they will send, in addition to the approval letter, they will send employment authorization. Now, if you file I-485 concurrently with your I-360, then you can apply for employment authorization based on the pending adjustment application. So employment authorizations are usually attached to a pending employment authorization. It is not attached to I-360. It is only when a VAWA petition is approved that an employment authorization will be issued based on the VAWA. But while the VAWA petition is pending, it is only adjustment application that is associated with employment authorization. Next question. Oh, are you good? Everything is working fine. I mean, video wise. Oh, okay. Maybe this person was just responding to when I thought I was frozen. Okay, thank you. Okay, next question. I tried to do a service request online, but then I got a letter in the mail saying I can't do it online because of the type of petition. How can I do a service request for my VAWA? Well, I don't know if this person is a self-petitioner or you have a lawyer. If you have a lawyer, I will advise you to consult with your lawyer, to contact your lawyer, because VAWA is a delicate petition. It is not a kind of petition that every officer or every USCIS office have access to. So even as the petitioner or even as lawyers, you cannot call them over the phone. You cannot communicate with them because those people who will respond to your communication or those people who will answer your phone, they don't have access to your file because VAWA is processed by a specialized office. Specialized office. That office is in Virginia. That is the only office that processes VAWA in the entire United States. So VAWA is not something that is processed at all or other USCIS offices. So if you are calling or if you are attempting to do a regular service request online regarding a VAWA, no, they do not have access to it. However, as lawyers, you can either write them to communicate with them, but we also have other tools that we use online to contact immigration online regarding VAWA. But it is not the regular service request process. That is not applicable to VAWA because those officers who are supposed to respond to those things, they do not have access to the VAWA file, so they cannot attend to it. So you can either send them a letter, or if you have a lawyer, let the lawyer use the attorney communication tool to get in touch with them. That is the only one that I can think of now of the means of contacting VAWA office. But you cannot do it with regular online access or phone call. Now, next question. I'm about to file VAWA petition, and I have 2 minor children that were also victims of the abuse. Do I need to file separate VAWA petition for them? What about adjustment of status? Good question. If you are a victim of abuse and you have children who were also victims of the abuse, your own VAWA petition is sufficient to take care of you and your children. You do not need to file a separate VAWA petition for the children. However, it is different with adjustment. When it comes to adjustment, everybody that is requesting a green card in the United States has to submit a separate application for adjustment. Even if the child is 1 day old, you have to submit a separate application for adjustment. Nobody can get green card on the basis of the mother's application or on the basis of the father's application. Green card application is a personal thing. So you have to submit adjustment application for each individual. But as far as the VAWA petition is concerned, that one the one that do file as their mother will cover the children. Now, next question. Please keep the questions coming. This is really interesting. We have a lot of questions today. Keep them coming. We are enjoying it. Keep the questions coming. Our next question. What is the age limit for children to be included in a VAWA petition? The age limit is 21. If your children are under 21, they can be included in your VAWA petition. The age limit is 21. The next question. I'm in the process of filing my VAWA petition. I have friends and family writing letters attesting to the legitimacy of the marriage and detailing the abuse suffered. Someone said that I had to get the letters notarized. Is this true? Why can't people just sign the letters? Well, let me tell you this. People can write letters and just sign it. That is not the main thing. People can also write letters and notarize it. That is not the main thing. It is not the letter itself that matters. What matters is the content of the letters. What matters is the content of the letters. Having said that, when something is notarized, especially if it has the notary jurat, if it has the perjury jurat, it carries more weight. If it is notarized without the perjury jurat, it does not carry any weight other than the one that is not notarized. Now, you may be wondering, what is perjury jurat? When you state at the beginning of the letter that I write this under the penalty of perjury, then it becomes a sworn statement and it carries a lot of weight, because you are telling them that, look, if this statement turns out to be untrue, I'm willing to face the consequence. So it carries weight. You are putting yourself at risk. So it carries a lot of weight. But having said that, it is not the notary itself that determines the weight such letters will get. What determines the weight that the letters will get is the content of the letters. When you write a letter and you put yourself in a position as if you are testifying about something that you didn't have knowledge of, it does not carry any weight. When you write letters and come up with conclusory statements, it does not carry any weight. But when you write letters and you state the facts as a witness, that is when it carries weight. I know that what I'm trying to say now may not be clear to some people. Let me give you a couple of examples. Let's say somebody approached me. Now I'm treating myself not as a lawyer, but let's say a friend of mine approached me that, oh, I want you to write a letter for me to support my VAWA application. And I write something like this. My name is so person. I'm writing this letter to confirm that A and B are married. They love each other. They are a wonderful couple. They are this, they are that. And I wrote all those things and I sign it. The question is immigration going to accord any weight to that type of letter? The answer is no. The answer is no. They are not going to accord any weight to that type of letter. The answer is no. Because that is a conclusory statement. You are saying A and B, they love each other. How do you know they love each other? Love is a thing of the mind. How do you know? So you can't just write letters and jump to conclusion and then you want immigration to rely on your conclusions. No, that's not the way it works. They are not going to rely on such conclusions. So it does not carry any weight. On the other hand, if I write a letter like this, well, for the purpose of this podcast, I want to sound this disclaimer. All these examples that I'm giving, please do not write it in your letters. Do not write it in your statement. I'm giving these examples to clarify questions. I have seen people that when I try to explain things to them, they go back and write it verbatim, the way I describe it. I'm giving a caveat. This is for the purpose of explanation only. Do not go and write what I'm about to say or what I've been saying. I'm not a witness to your marriage. I cannot tell you what happened in your own marriage. I cannot tell you how to present something that you claim you are a witness to. So this caveat, please note it. Now, if still back to my example, if I want to give my friend a letter, and let's say my letter says something like this: my name is ABC. I'm a US citizen. My address is this. And if you need to contact me, this is my phone number. What I'm about to say now, I'm saying it under penalty of perjury because I'm stating what I witnessed. A and B used to be my neighbor. I used to live at XYZ apartment. A and B used to live at the next door apartment to me. We used to visit each other. Many times we meet at the laundry. My wife and A's wife, they also attend the same church. Our children go to the same school, by virtue of which we all attend after-school program together. We do a lot of things together. I'm in a position to observe A and B, and I can tell you, based on my observation, that A and B love each other. They seem to be in love. I've witnessed this, and I'm basing my opinion on my observation of them. That is completely different from the first example. So this one will carry a lot of weight. Except immigration have access to public information or public record that can dispute what I have written, that letter will carry a lot of weight. So, again, the weight that a letter carries is not about whether the letter is notarized or not. It is more about the content of the letter. Okay, next question. Is there a time limit after my divorce to file for VAWA? I didn't know I could file VAWA and just heard about it, but I got divorced a little over a year ago. Is it too late? Well, good for you. It is not too late. You can still file VAWA petition before any time before your divorce is 2 years old. The moment you are divorced for 2 years, you can no longer file VAWA. But again, you have to be sure that you are eligible for VAWA before you file it. But the timeline is 2 years. The cutoff is 2 years after divorce. So if you have been divorced only a year ago, you are still eligible for VAWA. Next question. I went back to Nigeria because I didn't feel safe or protected from my husband. Is there a way to file VAWA from here in Nigeria? Well, there are so many things to... I will need more information from this person before I can determine the answer to this question because, like I said, immigration is not a one cap fits all. So it's not a yes or no question. It's not something that I can just tell you, yes, you can file, yes, you cannot file. There are lots and lots of information that we need in order to make that determination. For example, I don't even know if this person is divorced or not. I don't know if the divorce has been 2 years. There are a lot of things that we don't know. But simply put, if you are eligible and you meet the requirement, your location is immaterial. You may still be able to file it despite the fact that you are no longer in the United States. So that is the only thing I can say. But whether you are eligible or not, those are things that I cannot say based on this simple question. Please keep the questions coming. Keep the questions coming. Keep the questions coming. And please remember to invite your family and friends. Remember to subscribe to our channel so that when we go live, you will be notified. Keep sending your questions. I believe that our numbers are displayed: 817-983-44999. Keep sending the questions. Okay, the next question. You mentioned that a parent can file based on an abusive child. My son was addicted to drugs and very abusive, but he actually passed away from drug overdose. I didn't see the question here. I think I have an idea of what the question is. Well, let me tell you this. The fact that the fact that your child is dead does not mean you cannot file VAWA. You can still file VAWA despite his death. However, what is important is, did you even meet the requirement? Because I don't know if the writer of this question joined us from the beginning or is just joining now. Because these are part of the things that I explained at the beginning. The fact that this person is on drug, that is not abuse. That is not abuse. If somebody is on drugs, if somebody is using alcohol, if somebody is cheating on you, those are not evidence of abuse. So you first have to make a determination that you are even eligible before you start talking about whether the child is dead or not. But to answer your question, the fact that the child is dead does not mean you are not eligible for VAWA, especially if the child's death is less than 2 years, you will still be eligible. But the question is, are you even eligible for VAWA? Because based on what this person has written here, this is more about addiction. This is more about drug. How have you been abused? So those are the things that you need to determine before you consider VAWA. But to answer your question, the fact that he passed away does not stop you from filing for VAWA. So keep the questions coming. Is there a reason why I didn't see other questions? Please keep the questions coming. It's encouraging when we have these questions. Maybe you have to be reading it because I still cannot see any question, any more question.
I came in on a K1 fiance visa. We got into a bad argument, and my wife recently filed for a restraining order, and it was granted. I had to leave the house with absolutely nothing, and she is threatening divorce. My wife has not filed anything with immigration other than the K1 visa. Can I still file for VAWA? That's a long one.
Can you please repeat it? It's actually beneficial if I'm able to read it myself, because I also want to be able to read it to the listeners so that everybody will know what the question is. And then, is it on that other phone? Okay. I came in on a K1 fiancé visa. We got into a bad argument, and my wife recently filed for a restraining order, and it was granted. I had to leave the house with absolutely nothing, and she is threatening divorce. My wife has not filed anything with immigration other than the K1 visa. Can I still file for VAWA? Well, there are so many unanswered part of this question. There are so many information. I keep saying that immigration is not a one cap fits all. It's not something that I cannot say yes or no without additional facts, without additional information. For example, when somebody entered the United States with a K1 visa, why is that one showing? Sorry, listeners, we have to take a short break. This system is not performing well today. I don't know what is going on. So let's just take a 2 minute break. 2 minute break. Okay, welcome back. Thank you. Sorry about that. I think having to reboot really worked. Things are probably back to normal now, even though I'm still not able to see additional questions on my phone. Okay, this is Dr. Olu Asekun here again. Welcome to our live podcast. Today, we are discussing VAWA. Remember to join us every Wednesday, 12 p.m. That is Dallas time, Central Standard Time. We do this free of charge. Remember to invite your family members, friends, so that they also take advantage of everything we are doing here today and every Wednesday by God's grace. It is not good to be selfish. Let others also benefit from this information. The reason we are doing this is to educate people so that they avoid unnecessary errors, unnecessary mistakes, and also give them information on the right things to do and what to avoid, so as to be able to eat the fruit of the land. We are discussing VAWA today. Before our break, somebody asked a question. I came on a K1 visa. We got into a bad argument, and my wife recently filed for a restraining order, and it was granted. I had to leave the house with absolutely nothing, and she is threatening divorce. My wife has not filed anything with immigration other than the K1 visa. Can I still file for VAWA? Yes, before the break, I was explaining that there are issues there are more information that I need relating to this particular question in order to properly answer it. But I will tell you this. K1 has a lot of other requirements, sub-requirements. When you come into the United States on a K1 visa, you are required to get married to your spouse within 90 days, within 90 calendar days. That is within 3 months of entry into the United States, you are required to marry. So the first question I have for this person, which unfortunately I don't have the answer. I don't know whether after coming into the US, have you been married? That is a question I don't know. So, because if you are here and you have not been married in 3 months as required by your K1, that will create an additional hurdle for you. That has nothing to do with the VAWA thing we are discussing today, but I'm just telling you that will create an additional hurdle because it will make immigration doubt your intent in the first place. If your intent in coming to the US was to come and marry, which is what K1 visa is all about, if your intention is to come in and marry your spouse, and you are given the K1 visa and you have been here for 90 days and you did not marry, then that will raise some other challenges. But to answer your question in the simplest way possible, the fact that your spouse has not filed anything for you with immigration does not prevent you from qualifying for VAWA for as long as you have the evidence of VAWA and you meet the requirement. So the answer is very clear. You can still file your VAWA despite the fact that your spouse has not filed anything with immigration. But the first question you need to address, when you are given a K1 visa, you are telling them that you want to come to the US to come and get married. And here you are given visa and you are given up to 90 days to get married. So if you have been here for 90 days and you did not get married, that in itself will raise question about your intent in coming to the US, except if you can link the inability to get married to the abuse. If you are able to link it, yes, that may be some ways to cross that hurdle. But the question is, are you able to file VAWA despite the fact that your spouse has not filed anything with immigration? Yes, the answer is yes. Okay, I think I've started getting questions now, even though I didn't get the latter part of the first question, but I'm getting questions now. I have a new question. Okay, how long does the VAWA process take? Oh, these are questions that I cannot answer. Those are not specific questions. We want questions more about VAWA, not about how long. Those are things we don't have control over. We don't have control over processing time, especially since COVID. Those are things we do not have control over. So I've seen VAWA petition being approved within 1 year, and I've seen VAWA petition that was not approved in 4 years. So we don't have control over the timing or the how soon it will take. Those are questions we cannot answer, except I just want to guess. And guessing is not part of what we want to do here. for this for the purpose of this podcast. So keep the questions coming. Do you have any other question there that I don't have here? Because okay. So keep the questions coming. Keep them coming. Keep them coming. Keep the questions coming. Today we are discussing VAWA. Remember to subscribe to our channel so that when we go live, you get notification. Also, remember to invite your family and friends so that others too can take advantage of all this information we are passing out. Yes, I think we have more questions. I got married to a USC 3 months ago. I had not been added to the list or anything yet, but I have plenty evidence of abuse. Can I still file for VAWA? Well, again, these are the type of questions that requires additional information because I don't want to be misquoted. I don't want to be misquoted. I don't want to give you false hope. And I also don't want to discourage you when you are eligible. So when you are asking this type of question, it is always good to provide more clear information so that one can have basis to review your case. I always say this, immigration is not a one-cap-fits-all. Immigration is case-specific. Case-specific. Somebody who has been married for 3 years, may not be eligible for VAWA, whereas somebody who is married only for 3 months may be eligible for VAWA. But again, every situation is different, so it depends on the specific categories. It depends on the specific needs. I don't understand what you mean by plenty of evidence. Well, what you consider plenty of evidence may be evidence that carries weight. It may also be evidence that is immaterial. So I don't have a way of knowing all of these things. So I don't want to just tell you yes, and then it turns out that you are not eligible. And at the same time, I don't want to tell you no when it turns out that you are a real victim that is actually eligible. So what I'm going to advise you is that we need more detailed or case-specific information. But to answer the question, the how long, it is not how long. That is not the determining factor. When it comes to VAWA, it is not how long you have been married. That is not the determining factor. Like I said, somebody may be married for 3 years and not be eligible for VAWA. And somebody may be married for 3 months and be qualified for VAWA. So it is not the length of marriage that matters. It is what happens in the marriage that matters. And the fact that you don't have a lease by itself is not the sole determining factor. There are other things that one can use as evidence to show that you actually live together as husband and wife. But if you don't have a lease, it may raise some issues, but depending on what you mean by plenty of evidence. So if there are other substantial evidence of commingling of assets, yes, without the lease, you may still be eligible, but it depends on the specific situation of your case. Now, the next question, this is probably a further clarification. We were married with family and friends, and I have evidence of the wedding, but no evidence of commingling of assets yet. Well, if you don't have evidence of commingling of assets, you are not eligible for VAWA. It's as simple as that. The evidence that I have is police report, hospital record, and a witness to the abuse. Okay, this is part of, you see, this is part of why it is dangerous to say yes or no to this type of questions. I'm just going to advise this person. The best thing is, I will advise you just consult with an experienced immigration attorney so that you present your specific case, and they will look at the totality of the case and then advise you accordingly. Because all these things that you have provided so far does not tell me that you are eligible, and also does not tell me that you are not. So it will require additional review. I think the best thing you need to do, consult an experienced immigration attorney just to be sure that you are eligible for VAWA, so that they can look at the totality of your case. So that is very, very important. The reason I cannot conclude just because you have a police report, I have seen police report where the victim called the cops. The US citizen also called the cops. Both of them called the cops. By the time I read the police report stated that, oh, this woman came to my house. You see, that statement does not show that they were living together, even though there was police report. So, but what is the content of the police report? So, by saying that there is a police report, there are witnesses, that may not be enough. In some cases, it may be enough, and in some cases, it may not. So, before I can tell you definitively yes or no, I think it is better and fair to me to know exactly what to have. So, my best advice for you, consult an experienced immigration attorney, let them review everything that you have, and then they will advise you accordingly. So that will be my response to that question. Please keep the questions coming. Keep the questions coming. Okay, I think we have a new question. I filed my VAWA, but they sent a RFE saying that I provided fraudulent evidence, but it is not true. What can I do? Okay. I'm sure this person either joined us late or not. I really don't know. But these are some of the issues that I addressed at the beginning of this program. And for the purpose of those who join late, I'm going to address it again. VAWA is very easy, but VAWA is also very dangerous. If you are not eligible, I will not advise you to file VAWA if you are not eligible. It is very important to file VAWA petition only if you are eligible. I stated at the beginning of this program that I have consulted with people who came to my office asking that I file VAWA petition on their behalf. After reviewing their specific case, I advised them that they were not eligible for VAWA. Several months later, I discovered that they went to another lawyer who actually filed the VAWA on their behalf. Again, I'm not here to comment on what other lawyers do or what they don't do. That is not the purpose of this podcast. The purpose of this podcast is to provide information to our people to prevent them from making avoidable mistakes. One of the avoidable mistakes is for somebody to file a VAWA when they are not eligible. Again, I'm going to restate this for the purpose of those who did not start with us from the beginning. VAWA is an application that immigration reviewed using 3 basic things. The first thing that immigration uses in making a determination regarding VAWA, they look at the story that the applicant wrote. Every applicant for VAWA must write a story. You have to explain what happened. How did you meet this abusive spouse? How long did you date? When did you get married? What was the situation of your marriage of your life after marriage? At what point did the abuse start? You have to state all of these things in your story. So immigration is going to consider the story. The second thing that immigration is going to use in making a determination is the supporting document. What supporting document are you attaching to your story? So immigration is also going to consider the supporting document, the supporting evidence. This is where things like your lease, bank statements, police report, all those supporting documents, immigration is going to consider it. The third thing, and the most important thing, in fact, this third thing is what gets a lot of people into trouble. The third thing that immigration uses in reviewing a VAWA petition is public record. It is one thing for you to provide a list showing that you and your wife live in Arlington, Texas. It is another thing for public record to corroborate you and your husband living in Arlington, Texas. If you presented a list that is saying that you live in Arlington, Texas, and public record is showing that your husband was living in Fort Worth, when public record shows that you are living in Arlington, that is problematic. That is problematic. And it is even more problematic because of the content of Section 204C of the immigration law, which says that where immigration make a determination that someone have entered into a marriage for the purpose of evading the immigration law, or someone has attempted or conspired to enter into a marriage for the purpose of evading immigration laws, no petition will be approved for such a person. So the law used the word shall. And I remember that many of my African listeners, we are all students of English. If you go back to your English knowledge, you will realize that when the word shall is used, it means mandatory. It means compulsory. So the law states no petition shall be approved. So indirectly, it's a form of a permanent bar. So if you file a frivolous VAWA petition and then this comes back, even if you marry American president later, you cannot get this petition, a new petition approved. So those are some of the dangers of filing a frivolous VAWA petition. So it is one thing for you to be eligible. It is another thing for you to submit a VAWA petition for the purpose of submitting it. So if you are in a marital relationship where you and your husband or you and your wife, generally you and your spouse, if you did not live together, it does not matter how many documents you put together, public record will expose you. It is even more dangerous where the other spouse, the American citizen or permanent resident, if this American spouse, for example, is obtaining benefit from the government, you may not know. If this applicant has submitted some applications or some other requests to the government, and the information in those applications are contradictory to what you are presenting, it is problematic. It is problematic. So public record is key. And to be honest with you, the client that I advised that he was not qualified for VAWA, it was based on even me as a lawyer. I'm not an immigration officer. I'm not a government agency representative. I don't have access to the kind of information that the government have access to. But even the little information that I have access to, if I run your background and I am not convinced that you are eligible for VAWA, then you can be sure that when immigration, the government agency that have the power and the resources to to access your public record, it will be more problem. So coming back to this question, it says, I filed my VAWA, but they sent an RFE saying that I provided fraudulent evidence, but it is not true. What can I do? Well, you have to prove that it is not true. You have to show evidence that it is not true. But what I can tell you, based on experience, I can tell you that immigration will never put it into writing that something is fraudulent when it is not. That I can guarantee you. Because unlike other parts of the world, everybody here is liable if they make false accusation. So to accuse somebody of fraud is a serious allegation. And I tell you, immigration too can be liable if it turns out that their allegation is not true. So from my experience, I'm not saying it is not possible, but I'm telling you from my experience, it is almost impossible for immigration to put down allegation of fraud when there is none. It is almost impossible. I can tell you that from my experience. But unfortunately, we are not going to be able to know what exactly they know, except what they listed in the RFE. So what you can do is just to find a way to disprove them. If you know for sure that it is not true, then you have to respond to it. But remember, it takes two to tango. You are involved in a marriage. So if you put your own house in order, if your spouse did not, it will still be problematic. So it is a two-way thing, double-edged sword. So what you can do is to provide overwhelming evidence that their allegation of fraudulent evidence is not true. And I want to add this. Thank God I don't even have a name because these questions were sent to me here from the office. So whoever sent this question, do whatever you can within your power to fight this fraudulent allegation, because if you don't, it's going to affect you permanently in this country and it may end up leading to deportation. So do whatever you can, whatever evidence you can get to show that this fraudulent evidence thing does not stand. Do whatever you can to disprove it. Next question. I was a victim of abuse by my USC spouse. We were together for 3 years, and he was actually convicted of crimes related to the abuse. Is it better to file for VAWA or U visa? Well, you can do either. You can do either. The only thing is, VAWA may be easier than U visa. Even though I don't know the details of the crime and all of that, but based on this question here, VAWA may be easier than U visa. The reason is this. For VAWA, all you need to do is to meet those 3 requirements that I listed. Evidence that you live together as husband and wife, 1. 2, evidence of the abuse. And 3, evidence that you yourself, you are a person of good moral character. Those are the only 3 things that you need to meet. But in the case of U visa, you need the police to certify. There is a form that the police will still have to sign before you can file a U visa. And in some limited situations, I have seen victims of abuse where the police department refused to sign the certification. So in the case of VAWA, your destiny is in your hands. But in the case of U visa, you need the police to cooperate with you. You need the police to sign a certification for you. So it depends on how easy you can get that. But if I were in your shoes, based on this information you provided, I will go for the VAWA, which does not require any police certification. Another question. Will the person that I'm filing the VAWA based on, my husband born in the US, find out about my VAWA petition? Well, this is a tricky question. This is a tricky question because I will tell you this. A lot of things have changed about VAWA in the last 3 years. A lot of things have changed. Ordinarily, petitioners or the abusers are not notified of VAWA. Usually, the abusers do not know that somebody has filed VAWA. But because of the alarming number of fraudulent applications that immigration has been receiving lately regarding VAWA, they have started conducting extra investigation into the relationship. So, and I've seen some of these recent investigations where they will have to question the abuser. They are not going to question the abuser about the VAWA. They are going to question the abuser about the marriage. So there are two different things. So the fact that they decided to contact the abuser, they are not going to tell the abuser that, oh, your wife or your ex-wife filed VAWA, that is why we are coming here. No, that is not what they are doing. So to answer this question, the abuser may not know that you filed VAWA, but the abuser can be contacted in the process of investigation. Like I said, in the last 3 years, because of the alarming rate of fraudulent VAWA application, investigation into allegations of abuse has increased tremendously. It has increased tremendously. So for now, they conduct more investigation because, I mean, come to think of it, put yourself in the position of immigration officers. If you handle 10 cases and maybe 7 of them turns out to be fraud, when you receive the 11th case, how are you going to treat it? You are going to treat it more with caution. You are going to treat it more with the presumption that this one too is fraud. And that is exactly what is going on now. To add to it, let me say this. To add to the fraudulent VAWA petition lately is another challenge of foreign divorce decrees. That is another thing that has triggered extra investigation, not only into VAWA cases, but into all immigration petitions generally that is based on family relationship, especially where divorce is involved. For those who have submitted foreign divorce decrees, because majority of these divorce decrees turns out lately to be fraud, to be forged, to be inauthentic. It has increased the view, immigration's view, to many of these VAWA petitions. So it is interesting to know that they are not taking people's word for it the way they used to do in the past because of the level of fraudulent petitions they have been receiving recently. Please keep the questions coming. Keep the questions coming. I believe we have about 33 more minutes. So keep the questions coming. No, about 23. Sorry, 23 more minutes. So keep the questions coming. I mean, we are enjoying it. Keep them coming. Just remember to subscribe to our channel so that when we go live, you get notified. We'll keep doing this by the special grace of God every Wednesday, 12 p.m. Central Standard Time. So invite your friends, family, so that they also be a partaker of this free information. Okay, the next question. My spouse filed from I-130 for me, but I'm really scared of how he is treating me and is threatening me and hurting me. How will I go about changing the petition? Well, what is it? Well, I'm going to advise you to consult an experienced immigration attorney because the information here is not enough for me to really advise you, because saying that he's treating me and he's threatening me and he's hurting me, well, I'm not sure if those things are enough for you to change the petition. But if you believe that you have sufficient information, my advice is just consult an experienced immigration attorney. Let them review your situation and advise you accordingly. I stated at the beginning of this program that culture has to do with what immigration will consider abuse and what does not constitute abuse. So if this person is threatening you, it depends on how. But let me be more specific. What constitutes abuse is when somebody is using his or her position to manipulate you, to kind of control you, to kind of subdue you, to kind of maybe determine what you do and what you don't. So that is what constitutes abuse. It's not about somebody is drinking. It's not about somebody is cheating on me. It's not about... So when you say somebody is hurting you, I do know as a man myself that if your husband, for example, is cheating on you, you will be hurt. So when you say somebody is hurting me, so what originates that hurt? Is it an action that constitutes abuse or not? That's not something I can determine based on this question. So that is why it is always better to consult an experienced immigration attorney in order to make a case-specific recommendation or a case-specific determination of what to do next or how to go forward. So very, 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 very important, because without understanding what is hurting you, it will be difficult to determine if what is hurting you is what is eligible for what can lead to an approved VAWA petition. So that will be my answer to that question. The next question: what if my abusive spouse has been deported? He had a green card when the abuse happened but was deported. Will I still qualify? Again, immigration is not a one-cap-fits-all. These are not yes or no question. As I stated during this podcast, there are factors that has to be considered. For example, are you still married to this person even though he has been deported? Are you still married? Have you filed for divorce? If you have divorced, how long ago have you divorced? So there are so many things that we have to consider before we can say yes or no. But assuming that all the dots are crossed, yes, the answer will be yes. The fact that he was deported will not stop you from being eligible for as long as you meet other eligibility requirements. But the fact of deportation by itself will not stop you from qualifying for VAWA. So that is all I can say here. But whether your case is specifically eligible for VAWA depends on a lot of other things. So the first of which is, are you still married to this person? Are you already divorced from this person? If you have been divorced, how long has your divorce been? Because If you have been divorced for 2 years, you will no longer be eligible to file for VAWA. But the fact that he was deported does not mean that you cannot file VAWA, especially if the deportation has to do, is also related to your VAWA. For example, if he had a green card, for a green card holder to be deported, I'm sure he must have committed some crime. So if this crime has to, if part of what led to his criminal conviction has to do with the abuse, yes, you will still be able to file your VAWA despite the fact that he was deported. So you will still qualify. But you also need to know how long ago have you been divorced, if you have been divorced. And if you are not divorced, then you are still qualified. But I will still advise you to seek further analysis from an experienced immigration attorney. So that is that. Please keep the questions coming. We have about 15 more minutes to go, but keep the questions coming. 15 minutes is still a lot of time. We can still answer lots and lots and lots of questions. In the meantime, we want to remind you, we do this every Wednesday, by God's grace, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. Please subscribe to our channel on YouTube, on Facebook, so that when we go live, you get notification. And also, invite your friends so that you are not selfish, so that you don't get all this information free of charge when you are denying others the benefit of the same. We are doing this not for fee, not for any hidden agenda. We are doing it not because of anything hidden. It is only the drive to help our people, the drive to prevent avoidable mistakes, avoidable errors, the drive to provide information. That is the only reason we are doing this. So keep the questions coming. Okay, I think there's another question. Okay, my spouse was physically abusive, but I never filed a police report. How will I prove abuse? He was extremely controlling, so I really do not have much evidence. Well, this may be a difficult one. If you don't have much evidence, it will be a difficult one, because all these things are based on evidence. And when you look at VAWA petition, immigration is not going to call you in for interview relating to your VAWA. They are not going to call your husband and ask VAWA-related questions. All they are going to do is to rely on the evidence that you provide and then use public record to corroborate the evidence and to also corroborate your story. So if you don't have evidence, there will be nothing to corroborate. So it's going to be a difficult one. However, having said that, in some limited situations, assuming that your stories are consistent with public record, in some limited situations, immigration can approve your VAWA based solely on your story. If your story it turns out to check out. Remember, even if you don't have evidence, you probably have witnesses. You probably have other things that you can show. But the most important, if immigration, after pulling the public record, checking the public record regarding you, checking the public record regarding the abuser, if all these things tally, yes, the VAWA petition can still be approved in limited situations despite you not having the evidence. But the VAWA also could be denied despite your overwhelming evidence if the overwhelming evidence is not supported or corroborated by public record. So it is very important to understand that it is not the evidence per se but the evidence has to be corroborated by public record. And I believe I gave some examples of that earlier in this podcast. So if you are just joining us, maybe once we are done, you can go back and log into our YouTube channel and listen all over again. Okay, another question. Okay, before I go into other question, this person says, my spouse was physically abusive, but I never filed a police report. Now, I want to say this. If this person was physically abusive, there are other evidence that you can present aside police report. For example, if maybe while this person was hitting you or something, maybe there has been a situation where you have been injured and you have to go to the hospital, or you have to go to receive treatment. And of course, when you go to any hospital for treatment, they are going to ask you questions. How did you get this injury? What happened? Did you fall down? Did you do this? Did you do that? So all those type of things could be additional evidence. You can go back to the clinic or the hospital where you receive treatment to obtain medical record. So if all these things corroborate your story, yes, you can still get approved. For example, if you stated that, oh, I maybe as a result of the blow to my face, I had a black eye or something. Yeah, if you are able to show a picture of yourself, especially a dated picture showing that you had a black eye at that particular time that you claim that the man hit you, those are secondary evidence that can still be considered. So there are lots and lots of ways that you can still gather evidence in a situation where you are physically abused. Okay, let's go to the next question. We have 10 more minutes to go. So the next question. I have an approved I-360 VAWA. I'm about to file for my adjustment of status, but my children are still abroad. How can I file for my kids? Well, if you are physically here, your VAWA has been approved and your children are outside the US, your children cannot be included in your adjustment application because adjustment is only filed when the applicant is physically present in the United States. However, having said that, it depends on your age. It depends on the ages of your children. If you file your own adjustment application and your application is approved, upon approval, you can follow a process that can enable your children to join you for as long as they are under 21 at the time that your adjustment is granted. Well, let me clarify that because in some cases they may be under 21 and still not be eligible. There's a process known as follow to join. So there's a process known as follow to join. So as soon as you get your adjustment approved, so you just go through that process that is known as follow to join. If you use that follow to join process, you will need to file what is called Form I-824, application for action on an approved petition. So that will give you a priority date. The date that the I-824 is filed, that is the date that will give you a priority date. So it depends on a number of factors. Your children may be able to be eligible for protection under the Child Status Protection Act for as long as they were under 21 at the time that the I-824 was filed and visa was current in the category at the time the I-824 was filed. So yes, your children can join you, they can be a partaker of your green card, but they cannot file adjustment together with you because adjustment applications are only filed by someone who is physically present in the United States. But go ahead, file your own adjustment upon approval, then go through that process called follow to join, and then your children will be able to join you for as long as they are under 21 and visa is current at the time the I-824 is filed. they will be protected under the Child Status Protection Act, so that even if they turn 21 while the case is pending, they will still be able to get their green card. Okay, the next question. You mentioned the prima facie determination. If I apply for public benefit, will it hurt my green card application? No. If you apply for public benefit based on your prima facie letter, no, it will not affect your green card application, because one of the benefits of VAWA is that VAWA actually allows an applicant or a petitioner to actually apply for public benefit. VAWA is one of those applications, one of those petitions that allow the petitioner or the beneficiary to apply for public benefit. So they waive the requirement of having to have a joint sponsor, having to submit affidavit of support. All those things are waived in the case of a VAWA petitioner. So once you have the prima facie determination letter, actually in the letter, it states clearly, the letter usually states very clearly that you can use this letter to apply for public benefit. So applying for public benefit will not affect your green card application or your adjustment application. Next question. I did not know the requirement and filed VAWA on my own, and it was denied. Can I refile the VAWA with more evidence? Well, it depends, because usually before they deny a VAWA, they would have issued you a request for evidence. They will have given you an opportunity to provide more evidence, and they will have stated clearly the nature of the evidence they want you to provide. So usually they don't just deny petitions, not only VAWA. In fact, there's a part of the Immigration and Nationality Act that states that where immigration comes across an information that will be adverse to a petitioner or to a beneficiary, immigration must bring that information to the attention of the petitioner or the beneficiary and allow the petitioner or beneficiary to respond to those information before taking a decision on the application. And that is one of the reasons why immigration issues either request for evidence or notice of intent to deny. So usually they don't just go ahead and deny something. They will have given you opportunity to respond, to provide additional evidence. So the reason I cannot tell you whether you can refile or not is I don't know if you are already divorced. I don't know if your divorce is already 2 years, because since this petition has been denied, any new petition you file is going to be treated as a new petition. So all the requirements will be looked at as a brand new application. So if your divorce is already 2 years, then you will no longer be eligible for a new VAWA application. However, having said that, I want you to go back and look at the denial letter. If the denial letter, assuming that your divorce is already more than 2 years and you are no longer eligible for a brand new VAWA petition, go back and look at the denial letter. If the denial letter was still within 30 days, you can still file a motion to reopen and present additional evidence. On the other hand, if the denial letter has been more than 30 days, again, look at the date. If it was denied before March 25, if it was denied before March 25 of 2023, but within the last 90 days, you may still be able to file a motion to reopen based on USCI's flexibility in operation before March 25 of 2023. So you may still be able to file a motion to reopen, and you may still have the opportunity to present additional evidence to get your VAWA approved. Well, that is the last question I have here. Do we have any more questions there? Can you check the WhatsApp? Let's see. So that we don't round up without answering any other question. Okay, there's one more. Okay, let me have the question. That will probably be the last question, so waiting for this last question. In the meantime, again, remember to join us next Wednesday. We'll be doing this by the grace of God every Wednesday, 12 p.m. Central Standard Time. In fact, sometimes before the end of this month, we will probably be bringing in guest speakers so that it will be more interesting. We are thinking of bringing in guest speakers. At least we bring in other immigration professionals, so that sometimes you hear divergent opinions. So we are thinking about that. So make sure you subscribe to our channel so that whenever we go online, whenever you go live, you can be notified. Remember to invite your family and friends, so that they will also be partakers of this free information. Do not be selfish. So here is the last question for the day. Can you travel with an approved VAWA? I don't have my green card yet, but I applied for it, as well as EAD and travel document, but I have not heard back on those three yet. Well, if you have an approved VAWA, you can travel for as long as you have the travel document approved. So you have to wait for the travel document to be approved. If your travel document is not approved and then you step out of the country, you may not be able to come back into the United States. In addition, your adjustment application will be denied, because the law is that once a pending application for adjustment has not been determined and the applicant travel out of the U.S. without travel permit, it is presumed that the applicant has abandoned the application. So that is the position of the law. So if you travel, the application will be denied. The application will be denied. So it is better to wait for travel document. But once you have your travel document, then you can travel while your adjustment application is pending. So I believe I've been able to clear that. So with that, we come to the end of this week's podcast. It's been very interesting. Again, we are doing this every Wednesday, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. Please subscribe to our channel so that when we go live, you get notification. In addition, invite your family, friends, so that they also can be partakers of this free information. We are not charging for this. We are doing this only to provide information to our people and to prevent our people from making avoidable mistakes. So it will be unfair on your part. It will be unfair to me if you keep this free information to yourself. As you are getting this information, let others also partake from this. Invite others to be part of it. Thank you once again. We appreciate your time. And remember to join us again next week Wednesday, and every Wednesday, 12 p.m. Central Standard Time. Thank you. See you next week.
Principle was that it was a man that you can rely on. they work with me. They work with me like, it became something like family, right? It was no longer like, okay, this is a client, this is somebody it's providing you service, right? So it became something like a family. So yeah, I can see the relationship was good working with his staff. People give me encouragement, but I will look at it and say, how is it possible? I said, it is not going to be possible. That's why I kept telling myself that it's not going to be possible. But he knew what he was doing. Like I said, research is very, very important. If you do research, you will learn a lot of stuff. There are a lot of immigration rules some people don't look at. There are loopholes there, and sometimes they purposely put them there. So it's research, and it's using those research to help a lot of people, not just me. It is not just me. It is a lot of people here many people here that he has helped. Many people. Sometimes it doesn't even charge them. When it comes to the point that it doesn't even charge them. So yes, if you are looking for an immigration lawyer, even if I'm sleepy right now, if I'm like sleepy, you wake me up, you say, do you know any immigration lawyer? I won't even blink, I will say it. Dr. Asekun is there, I will just say it. So yeah, that's how good he is.
Talking about immigration, as an immigrant myself, I always put myself in the shoes of clients because I've passed through the immigration process and I know how hard it can be on people when they don't have the legal documents to work or to do day-to-day activities here in the United States. So that personal touch makes a big difference.
The law office of Olu Asekun is special because we like to put ourselves in our client's shoes.
For Dr. Asekun, for me, I will forever be grateful, and I keep telling people he's the best immigration lawyer you can have. He's the best immigration lawyer you can have. My first impression was that he was a man that you can rely on. They work with me, they work with me like, it became something like family, right? It was no longer like, okay, this is a client, this is somebody it's providing you service, right? So it became something like a family. So
another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family, and call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I was okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in our face and we were able to get her substantial amount of money from the insurance company. Even after paying all our medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own, and we all celebrated. It was a good thing.
Another interesting thing about our office.
I was looking for Lawyer Asekun for help concerning my immigration status because everything was upside down. Because I couldn't believe, I was even thinking maybe I'll be sent out back to Nigeria. So on getting to know him, he explained everything to me, what I'm going to do, that he's going to do everything. So fortunately for me, everything was done from him. Dr. Lawyer Asekun is the best lawyer so far in Texas because I can introduce as many as whoever is having problem, especially when it comes to immigration. I'm going to introduce Lawyer Asekun because he's the best lawyer. So far, so good.
Our goal here is to make our clients happy, especially in the area of immigration, family law, and personal injury.
I was looking for Lawyer Asekun